My name is Susan Mason, and I'm the Patient Services Manager at the Leukemia and Lymphoma Society. And this program is brought to you by the Leukemia and Lymphoma Society, as well as Novartis and Cancer Treatment Centers of America and Volunteer Kansas. I love this program. It's for all of us and your friends and family, the things that we need to have in place once we're 18 and older. Karen Weber is our speaker, and she's really, really good. And with that, I'll hand it over to Karen.
Thank you, Susan. All of us over the age of 18 should be familiar with 4 estate planning documents. The first one is the durable power of attorney for healthcare matters. Realistically, any one of us could be in a very bad car accident, and the paramedics could arrive on the scene and find us unconscious and unable to speak for ourselves. And if that were to happen, if you've got a healthcare power of attorney document where you have named the people that you trust, you give them the legal authority to talk to the doctors and make medical decisions for you until you recuperate and are able to speak for yourself again. Very important document. A lot of questions I've received over the years. People say, can I name more than one person? Absolutely. You can name more than one person. It's very common. Husbands and wives will often name the other spouse as the first healthcare power of attorney agent, and then maybe they will name their adult children. And you can name as many people as you wish in this document. This healthcare power of attorney document can be very personalized for your individual situation. Sometimes the adult children who are named as healthcare power of attorney for parents, they say, Karen, do I become financially responsible for my mother if I'm acting as her healthcare power of attorney? And the answer is no. Husbands and wives have no legal authority to make healthcare decisions for the other spouse unless they've signed these healthcare power of attorney documents. Advanced directive language is end-of-life declarations. My healthcare power of attorney document includes some living will or advanced directive language. Why would you include that advanced directive end-of-life language in your healthcare power of attorney if you also need to have an entirely separate document? And the reason I note that under the healthcare power of attorney that you can include some advanced directive language, I have had physicians ask me on behalf of my clients, when I had it in end-of-life language in the healthcare power of attorney document, doctors sometimes have asked me, does your client have that separate document, that advanced directive living will document that is exclusively related to the end of life? Some doctors like to see that entirely separate from the healthcare power of attorney. They want to be sure that the client thought about it specifically and that it wasn't just tucked into the healthcare power of attorney document without a lot of thought and consideration. So I include that advanced directive end-of-life decision-making, like I said, in the healthcare power of attorney, but it's really important for all of us to have that separate document listed as letter C on our outline. We don't give up that decision-making power just by signing the document. We just have that document in place in case we later need it, in case we do become incapacitated. I want to reassure you tonight, the law in all 50 states, nobody else gets to make our health care decisions unless we do in fact become incapacitated or unable to communicate our own wishes. This is the document that you want to make many copies of, okay, and give copies to your doctor's office. Give copies to the people that you've named. Let's talk about letter B, the durable general power of attorney. This is the financial or business power of attorney. The general power of attorney is the legal document we get to sign while we're healthy, naming and appointing persons that we trust to pay our bills, file the tax returns, take care of business and financial matters if something happens and we become unable to do that for ourselves. Because if you think about it, if something's happened and we've become unable to communicate our own medical wishes, we probably are also in a position where we're not able to pay the monthly bills, file the annual income tax return, and keep up with the business and financial matters. The financial or general power of attorney is different. We could all sign a general power of attorney tonight, the financial power of attorney, and appoint the persons that we trust. And for the financial power of attorney, We can prepare this paper either way. We can prepare it so that, like the healthcare power of attorney, it's not valid or effective unless we do become incapacitated, or we can sign it so that the people it's immediately effective, so that the people that we've named could immediately go out and help us with banking and business transactions. I want to encourage everybody after tonight's program to go back to your own documents and pull them out and make sure that you have both healthcare power of attorney document and the general power of attorney document. I've learned over the years, a lot of my clients who thought that they had both of the durable power of attorney papers, they really had only that healthcare power of attorney document, which is important, but that general power of attorney can be very important as well. Most people are more familiar with the healthcare power of attorney document. We can sign a document called an advance directive or living will, which is really a third document, separate from the healthcare power of attorney, separate from the general power of attorney. It's our third document, the advance directive or living will. What the advance directive and living will document is, this is the document that talks about our end-of-life wishes. What would we want as an individual, Arlene? What would you want if you were in a persistent vegetative state, showing no brain activity? You know, with modern medicine today, machines can be hooked up to do the breathing for us if we're not able to breathe on our own. And a feeding tube can be surgically placed into the stomach to keep us fed if we're not able to take food for ourselves. And most of the clients that I have worked with over the years have said, you know, Karen, I don't consider that living. If the machines are performing all of my bodily functions like eating and breathing, most of my clients have said, I would want my family members to be able to tell the doctors when enough is enough. The document's really important, but if you haven't shared it with all of your family members what your individual wishes are, they might have different ideas about the end of life. And one of them may be certain that you would share their view, and the other family member named in your document is certain you would have their view. But if they heard it from you while you were able to communicate, they're going to know what your wishes are. So really important that we talk about these things. Let's talk about the fourth document, the last will and testament. It's the document that says, where is our stuff going to go when we pass away, right? I would like you to write down some information about a place where you can go and get a free healthcare power of attorney and living will document that's very good. It has a workbook. It asks us questions that we can fill in our own answers about end-of-life stuff. A couple of points on beneficiary designations. First of all, I like them because you don't need the lawyer. You're going to learn with beneficiary designations, each bank or investment company has their own form that they're going to want you to fill out. There's no one form that satisfies all banks, so it's kind of a tedious process. All right? And you want to be sure you're real diligent, that you do it for each and every little account that you have. Don't forget that little $1,000 CD that you set up for Christmas fund. Oh, and by the way, we can name beneficiaries of our vehicles. We can name a TOD, a transfer on death beneficiary for our automobiles. Guardianship and conservatorship is a probate court process. If a person becomes incapacitated and unable to speak for themselves, unable to pay their own bills because of a car accident or whatever, if that person does not have durable power of attorney documents in place, their family members are going to find themselves going down to the probate courthouse. And the probate court judge is going to decide who should have legal permission and authority to make my health care decisions and pay my bills. And that judge will appoint someone to be my guardian. A guardian is a person who's been appointed by the court to make medical decisions for another disabled individual. And a conservator, the fancy word, conservator is a person who has been appointed by the court to make financial decisions for another disabled or impaired individual. There are insurance policies that we can purchase that will help us pay for assisted living or skilled nursing care if we ever need that. And I think these are good policies for us, all of us, to look into. Sometimes after age 80, my experience with my clients has been after age 80, usually the cost of this long-term care insurance is too expensive. It becomes unaffordable. There are other estate planning things that we can do to try and protect some of the resources from a complete spin down at the assisted living or skilled nursing center. And ma'am, this is where some of those irrevocable trusts come into play. It's one of the few times we want to have an irrevocable trust. Usually that only comes up when we're trying to protect some of our assets from a complete spin down at the nursing center.